Thank you very much, Madam President, all the distinguished delegates here. I am from India, as you can make out, but not part of an official delegation. I'm here at the invitation of someone whom all of you admire very much, Justice Lelio. In fact, when he first wrote to me about coming to this conference, I wrote back to him promptly. And I said, why me as an individual? I think you should have spoken to the people who represent the government and things of that sort. He said, no, we want you especially here. So I couldn't say no. But the moment I landed in Brazil, in Sao Paulo, I realized I was in all kinds of difficulties. I couldn't speak Portuguese. And without Portuguese, I don't think you can get along here very well. But anyway, now that I'm here, I, in fact, would bring things within a very close focus because of the time constraint, and I have a clear and imminent danger of missing my plane. Right. Tell me, all of you here, when we talk about child labor, what is that picture that comes to your mind? We have been discussing child labor since yesterday. A lot of things have been said, and a lot of things was said by Mr. Kailash Vidyarthi from his heart. He's also from India. I will be speaking basically on the law, since I was requested to speak of my little experience that I had of child labor in India, the judicial response to such child labor, and with particular emphasis on the role of the Supreme Court of India in trying to meet this challenge. When we think of a child who is doing child labor, really involved in child labor, we have pictures in our mind of children working in very difficult circumstances. We have in mind children who are working in mines, working in factories. We have pictures of children working as domestic help. We have pictures of children working in tea stalls, eateries, and the most difficult part is that these children are all within the age group of between, say, 6 to 14. This is the group of children who are in difficult circumstances, whom the entire world is trying to target, to try and see whether this could be eliminated once and for all. It's not an easy task. I know that 2016 has been set globally for complete eradication of child labor. It's a very, very difficult proposition. I don't know how it can be met, but from my own experience I've seen that there are various different problems, including social and political problems, which may not allow this thing to die down. Now, why are these children really preferred in certain industries we have found in India and maybe in other places as well? Why is it that these children are chosen particularly in regard to such child labor? There are really 2 or 3 important aspects. One is the poverty involved, as a result of which these children have no other alternative but to work. This is a very, very important issue as far as India is concerned. We have something called the below poverty line, which means people below a certain income, they come within this category. And children coming from this category below the poverty line, BPL line, well, they are people, they are the children who are mostly trafficked into the kind of work that they're being compelled to do. This is one group. You have another affluent group, not affluent, middle class group, who come out of his choice, not because they are forced, not because they are trafficked, but because of the fact that they are part of family businesses. They are part of family work. And this continues. A person, say for example, has a grocer's shop, or a tea shop, for example, a simple little shop like that. It's a family business. And family business is something which is outside the purview of any kind of regulation and prohibition that we have. So if the father sits in the shop, say for the morning session, during the afternoon it is nothing uncommon to see the child sitting there in the afternoon. This is part of family business. This is the second group. Then you have a third group who are street children. These are children who live on the streets and off the streets. These are children who have no place to go. They live on the pavements. And this is common not only in India, but in many parts of our South Asian countries and African countries. They work because they have no other place to go to and they have no other opportunities in life. These people are the people who are referred to by Professor Petit, that they turn to drug peddling. I'll come to that a little later. Do you know what a bidi is? Have you ever heard of a thing called a bidi? B-E-E-D-I. It's a poor man's cigar or a churut. And this industry is rampant all over South India. You have very, very famous brands. There's one brand called Ganesh Bidi, which is familiar in many parts of the world. It was at one point of time. You remember the days of the flower people, the hippies, the 1960s? Well, they were very fond of this bidi. What is this bidi? It's a bit of tobacco rolled up in a particular leaf used for the purpose. But just rolling it up won't let it stay. The tobacco won't stay inside. So you pinch in the sides. And then you tie it up with a bit of string. Nimble fingers make this work very easy. Children were employed in this kind of work till somebody took care of the entire industry, and a challenge was taken up by a senior advocate of the Supreme Court of India. I'll come to that a little later. But then, what are the laws which prevent or prohibit this kind of work? Why are these children here in the first place? Where do they come from? Who has sent them there? Who has brought them to this place to work in this fashion? These answers have to be found. Attempts are being made. Research work is going on about how and where these children come from. And I've told you about the poor families and things of that sort. You see, the ILO, for example. The ILO was founded in 1919. And in that very first year, 1919, we are talking about C-138, C-182. Well, in 1919, there was C number 5. The very first year, and that was related to age. As to what would be the age of a child. What would be the reckoning cut-off date for a child to be held to be a child? Well, 1919 ILO C5, subsequently ILO C59, subsequently 138, subsequently 182, 189. Has this still been resolved? Let me just tell you about some of the few provisions of our Constitution. I happen to be a person from a judicial background. That's why I'm here. In 1933, prior to India winning independence in 1947, we had a law known as the Child Pledging Act, 1933. What is this Child Pledging Act? This act was an act to prohibit parents from pledging the labor of their children for work. That act is still in force. 1948, 47 rather, 15th of August, India won her independence. 10th of December 1948, the Universal Declaration of Human Rights. 26th of November 1949, India adopted the Constitution. The preamble says that the Constitution was being adopted by the people of India to form a democratic, socialist, secular, sovereign republic. Of course, two words came in later by the 42nd Amendment, the words socialist and secular. That came much later in 1977. With the object of securing, first thing, justice. And what kind of justice? Social, political, and economic. Plus, we also gave to ourselves this Constitution for the purpose of ensuring equality of status, equality of opportunities. These are all there as part of the preamble, which I often refer to as the soul of the Constitution. This is now reflected. You will find that many of the provisions of the Universal Declaration of Human Rights find place in our Indian Constitution. Our Constitution comprises of 22 parts. 3 parts are very important for our purpose. Parts 3, 4, and 4 capital A. Part 3 deals with fundamental rights. These are rights which are guaranteed that every person is entitled to enjoy, and they are enforceable in a court of law. And the best part is that it contains an article called Article 32, which is the fundamental right to move the court to see that the rights are implemented. That itself is a fundamental right. Apart from that, Part 4 contains the directive principles of state policy. And these are the principles which have been laid down, which cannot be enforced in a court of law, but they are guidelines rather for good governance. And then you have Part 4, capital A of the Constitution, which came into the Constitution again in 1977, which deals with fundamental duties. Why am I referring to all this? Because there are certain provisions in the Constitution in these 3 parts which are very relevant for today's discussion. You have Article 14, which talks of equality. You have Article 15, which talks of no discrimination. And 15.3 empowers the governments, state and the center, to make special laws or laws special to women and children. And under this provision, many enactments have been made. You have Article 17, which bans untouchability. It says you cannot have this as a social, kind of a social problem which exists in India. So, no question of any kind of class or caste or caste or creed. Everything was totally prohibited. Then comes Article 21, which deals with a very, very innocuous sentence, a very, very innocuous sentence. A one-sentence article, but which has been interpreted by the Supreme Court, which is part of my brief here today. Article 21 says, no person shall be deprived of his life or liberty except by procedure established by law. That's all it says. At first sight, it seems to be pretty dull, sort of an article. But this article has been interpreted by the Supreme Court in various ways. Anything to do with a quality of life, living a life of dignity, has been included and brought within the ambit of this particular article. And this includes the right of children. This includes the right of people to have pure, fresh air, drinking water, ecology, right to education. All these become very relevant as we go along. Articles 23 and 24, I would like to read them out to you, because this also, being a fundamental right, is something which needs to be understood in the global context. I'll just take a minute. I've been asked by my translators to go a little slow on this because of the language problem. Article 23 says, in fact, the title is Right Against Exploitation. It says, prohibition of traffic in human beings and forced labor. Very, very relevant for us, because human beings do include children, or don't they? Traffic in human beings and begar. Begar is a form of forced labor without any kind of remuneration, and like bonded labor. And other similar forms of forced labor are prohibited, and any contravention of this provision shall be an offense punishable in accordance with law. Nothing in this article shall prevent the state from imposing compulsory service for public purpose. That's not really relevant for our purpose. Then 24. Prohibition of employment of children in factories, etc. This is extremely important because this has a bearing on the age issue. Prohibition of employment of children in factories, etc. No child below the age of 14 years shall be employed. Have I traveled all the way from India to speak for 10 minutes? Sorry, I'll have to disobey this. I told you I'm in danger of missing my flight, but I have to say a few words. I also happen to be the previous Chief Justice of India. As the previous Chief Justice of India, I don't think you can override me this way. Anyway, here we are. Prohibition of no child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. The age of 14 was the criteria. But this particular provision ultimately, along with, I'll try to be short, ultimately this particular provision read with in 1986, the Parliament enacted the Abolition of Child Labour Act in 1986. The prohibition and abolition of child labor. Now, this was in consonance with that, and we had 14 as the cutoff age for children to work in places where there were hazardous work being done. Up till that age of 14, a child could not be sent to these kind of places to work in. But there was no prohibition in them working in other employments where there was no hazards involved. Now, unfortunately, this law was not in consonance with the ILO convention that have been referred to. But then, India did take another step forward in introducing a bill in Parliament. A bill is the procedure prepared just before a matter can be brought to Parliament by way of legislation. The bill is introduced. And this bill was introduced for the purpose of increasing the age of children from 14 to 18 years in any kind of employment, hazardous or not. Well, since I have very little time, you remember the Beijing rules of 1985, which deal with children, and it deals with the minimum principles for the enforcement of juvenile justice, juvenile law. That was followed by, in our country, by the Juvenile Justice Act of 1986, These are all very relevant, and it's too short a time to discuss all this. In 89 comes the Declaration of the Rights of the Child. That was followed by the Juvenile Justice, Care and Protection of Children Act of 2000. There, for the first time, the age of 16, which was shown to be the age of majority for children, for male children, that was increased to 18. And do you know why it was done? It was in keeping with Article 1 of the Declaration of the Rights of the Child, 1989. What does it say? Article 1 of the 1989 Declaration says that all persons below the age of 18 shall be deemed to be children. There have been these developments in law. And this particular act, the Juvenile Justice Act, also contains a particular provision, Section 26, which makes the use of children up to the age of 18 years, children has been defined, up to the age of 18 in any kind of employment, a punishable offense. It has been made an offense which is punishable in a criminal court as well as it is punishable by fine. Apropos this, since we have to hurry up, the Supreme Court in fact entertained various litigation under a new branch of law which was referred to by Professor, and that is the law relating to public interest litigation, as different from private litigation. Public interest law stems from Article 32 of the Constitution, which I just referred to, and Article 226 of the Constitution, which I hadn't referred to, but it deals with the same powers that the Supreme Court has under Article 32 with Article for the High Courts to exercise. I spoke to you about this beedi rolling. There was a reason why I spoke to you about this. This very same gentleman, MC Mehta, no, sorry, not MC Mehta, this was done by the secretary of a particular district beedi workers association, who went to the court and they said children should not be employed here because this is a hazardous kind of work. Tobacco will affect these kids. Supreme Court intervened and gave directions that these children were not to be occupied in such kind of activity. Just prior to that, there was this, a letter was sent by this Mr. MC Mehta that Professor referred to. MC Mehta was a senior advocate of the Supreme Court. He had noticed children working in matchmaking and fireworks making in a place called Sivakasi in Tamil Nadu. He sent a letter, and that was treated as a writ petition. And on that basis, orders were passed preventing children being used in that kind of activity. That was reopened later once more, although it had been closed. So moto the Supreme Court reopened it. Why? A fire had broken out in Sivakasi in one of the factories when there was a lot of explosions. Children were involved. Some died. The entire thing was reopened, and thereafter directions were given so that these children were taken out, and as said by the professor, they were taken out and they were directed to be put in schools. And apart from that, the employers were asked to pay compensation. A certain compensatory fund was created. These are developments which took place as the law developed, the law of public interest. Right in front of me is Mr. Kailash Vidyarthi. He is one of the founders of an organization which is known as Bachpan Bachao Andolan, which translates as a movement to free children. Childhood, not children, childhood. That means liberate children so that they can enjoy their childhood and not lose their childhood in this kind of activity. They have filed a number of cases in court in the writ jurisdiction where orders have been passed. One of the latest cases was a case where children were employed in circuses. And they came forward and the court said that this is something, sorry? What is that? Oh, your finger was on the one. Anyway, so as a result, the court directed that these things should be stopped. These are practices which are being followed by the Supreme Court. There's another case recently where Professor spoke about innovation. There was a murder case involving a prostitute. Before the man who had committed the crime could be prosecuted and could be finally adjudicated upon, no, he was ultimately held guilty, and the matter came to the Supreme Court in appeal. And in appeal, that case, while it was pending, the man died. The appeal abated. That's the language that we use, the appeal abated. But the Supreme Court took upon itself to convert that into a public interest litigation, to see that the prostitutes, people who were working in the flesh trade, they were given protection. And I have sat on that case many times. We've passed orders at various different levels. And there were children involved there because the girls were below the age of 15, 16 and had been trafficked. Anyway, then there was, apart from the circus and this, there are many other fields. I don't think I can go into them, except for one more, and that is the field of education. Professor spoke about Unni Krishnan. There was before that a case of Mohini Jain, where it was held to be, education, primary education was held to be a fundamental right. It was never a fundamental right, but one of the rights included in the directive principles. By virtue of this judgment, the Constitution was amended, Article 21A was added, and right to education for children between the ages of 6 and 14 was made a fundamental right. Free and compulsory education. I could go on and on, but I don't think I can because of that 1 minute warning. So all I can say is that there are so many things which can be recommended, but then I think you can have recommendations done separately. But I would like to end on a certain quotation. I don't know whether it has been quoted here in any of the sessions, but this is a quotation which is one of my favorites, and it's from a person whom all of you should be knowing, Gabriela Mistral. What does she say? We are guilty of many errors and many faults, but our worst crime is abandoning the children, neglecting the foundation of life. Many of the things we need can wait. The child cannot. Right now is the time when his bones are being formed, his blood is being made, and his senses are being developed. To him, we cannot answer tomorrow. His name is today. Thank you, friends. I'm sorry for having taken so much time.